Is your mic on?
Oh,
there you go.
thank you.
Whenever you're ready.
Madam Chair and committee members, thank you for the opportunity to submit testimony on Assembly Joint Resolution 133, Assembly Bill 955, and the remaining bills under consideration. My name is Erin Gamble, and I'm Associate Counsel at the Wisconsin Institute for Law and Liberty, a law and policy center based in Milwaukee. Wisconsin's Constitution is explicit. The legislature writes laws, the executive branch enforces them, and the judiciary interprets them. Yet over many decades, the legislature has transferred broad policy-making authority to administrative agencies. While the legislature delegated its powers to the executive over the years, there was one saving grace. That is, the legislature maintained robust oversight over rulemaking. However, Markline 2, which was handed down by the Wisconsin Supreme Court last summer, has entirely changed the dynamic between the legislature and the executive branch. By limiting the legislature's ability to review or block rules without going through full bicameralism and presentment, the court has made it significantly more difficult for elected lawmakers to oversee agency action. As a result, the executive branch can write and enforce the laws of Wisconsin. If no changes are made, Wisconsin will increasingly be governed by laws not passed by the legislature, but by regulations written by agencies with little direct democratic accountability. We currently have an imbalance of powers which needs to be corrected. Thankfully, there are a few legislative fixes in front of the committee today that can help with that mission. First, Assembly Joint Resolution 133 would amend the Wisconsin Constitution. The proposed amendment would allow the legislature to suspend any administrative rule in whole or in part through passage of a joint resolution by a majority of both legislative houses. The suspension of an agency rule would last indefinitely or for a period of time specified in the resolution. With this constitutional amendment in place, it would permanently establish that the legislature has final say over rulemaking in Wisconsin. After all, rulemaking is a legislative function. Administrative agencies are nothing more than creations of statute. They have no inherent constitutional powers. They only exist because the people of Wisconsin willed them to exist by creating them in the state law through the legislature, and as a result, they have only those limited powers explicitly given to them by the people of Wisconsin. Because the power to write laws is inherently a legislative function, when agencies engage in rulemaking, they must strictly abide by the statutory process and be subject to all of the transparency and oversight measures contained therein. Therefore, when a majority of both houses of the legislature agree that an administrative rule falls outside the bounds of power that the legislature granted to the agency, the legislature should simply be able to pass the resolution to suspend the rule. This isn't a controversial or political proposition. Rather, it makes agencies responsible and accountable to the will of the people. Moreover, Wisconsin would not be the first state to ratify such an amendment. In fact, at least 6 states have amendments in their constitutions that allow state legislatures to suspend or nullify rules. Some state constitutions allow a single legislative agency to review and suspend rules, which is similar to how JCRAR could operate before Markline 2. Other states like Iowa and New Jersey require more input from the state legislature as a whole by allowing rules to be suspended with majority support from both houses. Assembly Joint Resolution 133 is a common sense solution which would reestablish legislative oversight over rulemaking, require bicameral action to suspend a rule, and ultimately make agencies accountable to Wisconsinites through their representatives. Next, Assembly Bill 955 would ensure that agencies promulgate rules only when the legislature has explicitly and specifically granted such authority in the statutes. Currently, Wisconsin Statute 227.11 sub 2a grants broad authority to agencies to promulgate rules interpreting, quote, any statute that, quote, they consider necessary to effectuate the purpose of the statute. With this current statutory language, executive agencies are essentially free to legislate on vast topics despite having no legislative authority or direct oversight. The result is that unelected bureaucrats now issue rules that carry the force of law, shape major areas of public policy, and impose real costs on Wisconsinites. Therefore, Assembly Bill 955 would repeal that deferential language. The current ill-advised language would then be replaced with statutory language that directs agencies to only promulgate rules that are explicitly and specifically authorized by the legislature. This is an easy legislative fix that would have a great impact. It would rebalance power and put policymaking back in the hands of the legislature. We appreciate this committee is considering bills that would restore transparency, accountability, and constitutional balance to Wisconsin's rulemaking process. Assembly Bill 994 would expedite the process to repeal rules and require agencies to hold public hearings and solicit public comment on rules before submitting an agency's mandatory biennial report. In a post-Markline II world, we risk the possibility that bureaucrats may write rules without ever having to face the person the rule affects. Therefore, WILL supports policies that require agencies to be transparent and frequently reconsider past rules. In sum, the Wisconsin legislature has delegated significant legislative powers to the executive branch, but the proposals in front of the committee today offer great solutions to bring legislative power back to where it belongs, in the legislature. Thank you for your time. Happy to take any questions.
Thank you for your testimony. Questions from the committee members? Seeing none, we'll take the next person.